Good morning. Welcome back to CMY View and Trust Station. Today we're going to continue our sharing again. Last episode we're talking about the revocation clause, which is so important because under the law the last will prevail. So if you have written two will, the last will be the one that is recognized by the court. So in the case when you have asset overseas, and it's advisable for you to write a separate standalone will overseas. That standalone will overseas should make sure that the revocation clause is properly drafted, that it will not revoke earlier will outside that particular country. This is to prevent the process called reseal, because to doing a reseal, the fee could be more higher and it can take a longer time. And I also share on the case of case study of Mr. Loke, whereby he has two family and he wrote a will for the first family and later write another will for the second family, which I told him that the second will actually revoked earlier will. So if that is a situation, the first wife will get nothing because anything that is not mentioned in the second will all fall under the residue estate and distribute accordingly. In the situation where there is a mistress or if there is a second family to be catered, in fact, there is another document that I would suggest that you subscribe to. It is called the Declaration of Trust. In the situation of this Declaration of Trust, basically it's a document whereby you assign specific asset to the trust, the Declaration of Trust, and you also give power attorney to Rockville or Trust Corporation. And subsequently, you also sign a trustee to mention when can this power attorney to be exercised by Rockville trustee or the trustee company. And also on the instruction, who is the beneficiary mentioned in the trust deed. So should something happen, then this the trustee company or Rockville trustee in this situation, for example, will exercise the power of attorney and transfer the asset from the person, which is the owner of the asset, and transfer it to the beneficiary. So this document is coming to very handy if you have a second family to take care and you wish to make sure that the transfer is to be discreet and unknown to others. So Declaration of Trust is a document that used to help to transfer asset without going through a will and without having applied grant of probate, or you can do it to transfer to specific person or second family. And this Declaration of Trust is also very useful when you have some asset that is part under a person's name, for example, a friend's name, but you can't ask him to write a will because he can change the will. And so Declaration of Trust come in handy, and by asking him to sign a Declaration of Trust and transfer the asset back to you, and when something happened, for example, death or his TPD, permanent disability. So we will share more on the Declaration of Trust in the coming episode. But remember, for writing a will, the last will prevail. Thank you.